Right, good afternoon. Phil Brunner, Bailiwick League, another Facebook Live session. Today's session we'll talk briefly about stamp duty and the family farm exemption. The current family farm exemption provisions were inserted into the Duties Act of 2008 and were amended provisions from the previous Stamp Act, but due to some changes to the terminology used, there's a perception that the exemption is somewhat more harder to obtain. So we'll talk a bit about that as we go. Firstly though, the information contained in this presentation is provided for information purposes only and should not be construed as legal advice on the topic or any matter at all, in fact. Who is Bailiwick Legal? Bailiwick Legal specialises in both agribusiness and tourism. We cover commercial, contractual and transactional law within those industries. And that will encompass many issues dealing with contracts, property, mortgages, financing, easements, trusts, leases, livestock issues, environmental protection issues and the like. So enough about Bailiwick Legal. Let's look at stamp duty. The key points in relation to stamp duty within Western Australia is that it will be charged on all dutiable transactions over land, the transaction and movement of land, unless an exemption applies under the Act. As I mentioned, a family farm exemption is provided for within the Act in particular circumstances, and generally, and I'll go through these in more detail in a little while, but generally the exemption will apply where the transferor is an individual family member and not acting as a trustee of an discretionary trust. Secondly, where the transferee is an individual or a company acting as trustee, but that provision will depend on the terms of the trust. And C, if the property is to be transferred to a trustee, then there's an issue about future transactions involving that property, intergenerational. Another key point is that transactional documents, typically your contract of sale of land or transfer of land, those documents need to be stamped within 2 months of execution. Now that can be a bit of a trap in the sense that people sometimes delay that process, but there's a more important aspect to that which I'll get to in due course. So let's go back and have a more detailed look at those three primary issues in the context of seeking an exemption to the payment of duty for a transfer of farmland. Now, typically within Western Australia, farmland is transferred in the context of the exemption to facilitate intergenerational movement of the business. That really means the older generation moving into retirement and the younger generation moving into the farming business. Under the prior Stamp Duty Act, the structure of the transferor was not as rigid as the current Act provides. I say that because the current Act provides that the exemption will only apply where the transferor, that is the person that's transferring the land to someone else within the family unit, is an individual. Now, as I said, that's a change from the prior provisions under the Stamp Act, which, though the prior provisions provided for a situation where the transferor could have been a corporate, or it could have been a trustee, including a corporate trustee, or a partnership of individuals that were then transferring the land to family members, typically intergenerational. Now, it's interesting because in 2007-2008, when the new duty bill was introduced, the fanfare was that it was the new provisions would help to streamline and assist for that intergenerational transaction of farmland. There's a view, which I hold, that is that contrary to that fanfare, these current provisions actually tighten and reduce the opportunity to obtain the exemption vis-a-vis the old Stamp Act provisions. So less transfers will now be entitled to an exemption simply because that the transferor now needs to be a person, an actual individual. Now, we all know that within the farming community, and in a commercial sense even, that land is not necessarily held by a person. In my experience within the farming community, typically land can be held by a person, by a company, or a company as a trustee of a family trust. And also that land can be held by several people, and occasionally not necessarily people that are farming the land, but could be family members that are off farm and doing other things but happen to have a registered entitlement to that land. So the structure of land holding within a farm business is quite varied. The current provisions in the debate in Parliament and in the explanatory memorandum were meant to deal with that variation, but they don't. The second issue that I'll turn to is that of the transferee, the entity or person receiving the land. Now, that person can be an individual, and the easiest situation, obviously, in the context of getting an exemption, is where the family farm is passed down from mother or father to son or daughter, or daughters and sons as a collective. So individual to individual. No question about that. An exemption will invariably be granted in those circumstances, provided of course that the farm has been used for farming for production, agricultural production purposes prior to the transfer, and is intended to be used post the transfer. Quite an important issue that in the scheme of the duty provisions. However, the transferee can also be a company as a trustee of a family trust. Now, this is again where things go a bit awry, I guess, in the sense of what then becomes exempt. There has been a decision back in, I think, 2012 where the transferee, the entity receiving land, was a corporate trustee, but the terms of the trust exceeded the parameters of the allowable family farm members. Now, in the Duties Act, there is a definition of who is a related person for the purposes of the exemption, and the related person, there must be a relationship. So, in the sense of the definition, you've got mother, father, child, of those two. I think it extends to brothers, sisters, grandparents, etc. So they're all people in the true sense of a person, and they are all family related people. Where trust deeds have, by definition, beneficiaries that are outside of that group, and if you have a look at your own trust deed and the definition of beneficiaries, depending on when that trust deed was formed and who in fact formed it, you will be able to assess your own ability here to transfer and whether the exemption applies. Because where a definition of beneficiary includes something like a company or corporate or a charity or a not-for-profit organisation, irrespective of whether you in fact distribute to any of those entities, the mere fact that they are by definition able to obtain a distribution from the trust means that the exemption won't apply because they aren't family members. A bit of a quirk, and one would have thought that the legislators would have recognised that so long as the controlling entity itself, like the company, is in fact controlled and owned by the family member, that should be sufficient. And even where, perhaps looking at the appointor roles, where the appointors and guardians of the trust are also family members, then that's probably a better criteria to determine whether the transferee meets the requirement for an exemption, rather than looking at who money can be distributed to within the trust itself. Anyway, that's again a limiting factor with respect to trying to get an exemption. The third point which I mentioned before was in relation to the corporate trustee. Where property is passed to a corporate trustee, and even where that trust only involves family members as beneficiaries, if there's a desire to transfer that land again at some future point to a family member in their personal capacity, it's likely that duty will apply to that transaction on the current terms of the Duty Act, because the transferor in this instance is actually a trustee and not a true person. So there are some traps and pitfalls in this whole process that we as lawyers really need to assess and look at, and you as persons trying to transfer your business intergenerationally need to be very conscious of. So the last point I want to deal with is the context of having your document stamped within 2 months of execution. Now when I say execution, that is 2 months of the documents actually being signed and then a valid contract is being created. we have had situations in the past where families have sought to prepare documents, occasionally through their farm advisors or accountants, where they think the duty exemption will be applicable. So they sign all their documents and then they come to us, or they go to the stamp office, Office of State Revenue, to get their document stamped, and they suddenly find out that duty applies, and then they go, whoa, stop this process, we don't want to pay duty, we don't want to go through this transaction anymore. And the problem with that, of course, is that once the contract is signed and becomes a valid contract, it must be stamped. Whether or not you want to proceed, it must be stamped. So the real issue here is, don't sign documents until you've obtained advice about whether or not you're going to be liable for duty. Because once you've signed those documents, they must be stamped. Now, there is a mechanism, obviously, where you might be able to not have to pay stamp duty, but if you simply want to cancel the transaction and not proceed, Office of State Revenue may well take a dim view of that and may consider that to be a case where you're trying to avoid paying tax, the duty, sorry. So, and that's a penalty in itself. Now, we won't deal with that now, but just be wary of that. So the point I make here, which I reinforce again, is don't sign any transactional documents until you're absolutely sure that duty is not going to apply. Okay, that really wraps up the session for today. Bailiwick Legal, we do provide advice and assistance with respect to duty issues and land transactions, typically in the context of business succession between, as I said, intergenerational issues for farmers. And we like to think that our advice is based on common sense and the business experience, strategy and realities of what's actually happening in situ. We do have experienced solicitors and personnel in the firm who can assist with that succession process and assist to cater for your client, your needs. Feel free to reach out to us at Bailiwick Legal. We do undertake free consultations, and hopefully we can put your mind at rest if you will allow us to assist you. Keep safe and well. Thank you.